We are on to online lecture 7, Rights of the Criminally Accused. Today we will be talking about investigations and evidence. The Rights of the Criminally Accused section really takes up the last half of our semester, and in many ways we could start and stop with nothing more than the Fourth Amendment and discuss that for quite some time. But I think it's important to look at it in context of a few of the other amendments as well and see what rights are available there. Now, the Fourth Amendment is very specific and yet, at the same time, is very ambiguous. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. Throughout that sentence, and it is just one sentence, there are several significant clauses that require definition and explanation. What is unreasonable? What's a search? What's a seizure? What's probable cause? When is something supported by oath or affirmation, and how particular is necessary for Fourth Amendment purposes to be particularly describing the place to be searched, etc. So you can see how each step of the way, the Fourth Amendment actually, although it provides us guidance, provides us with a lot of ambiguity. So it took some time for the development of a general rule, and in fact the general rule used to be pretty much on the side of the government. The government could essentially do what it wanted or needed to do in order to make an arrest. Now, that doesn't exactly frighten me as a concept, and it probably doesn't frighten you either, because up until this point technology was pretty limited. Granted, you did not go into people's homes without a warrant in a general circumstance, but when you did, people had heads up. People had knowledge that this was going to happen, at least to a certain extent. It was with the advent of technology that this became problematic. And so 1928, in the Olmstead case, the Supreme Court said that a wiretap on an individual's phone lines was just fine in terms of the Fourth Amendment, because the phone lines belong to the phone company, and you should not, you don't have the right to them, and there's no trespassing into the home, so the government can listen. But the Katz case, Katz versus U.S. 1967, changed that. The Katz case is an interesting one. One, because it involves phone booths, and we don't have those really anymore. But two, because it really challenges our conceptions of reasonable expectations of privacy. In fact, it develops this idea of a reasonable expectation of privacy. In Katz, you had someone who they were trying to investigate doing criminal activity, and they believed this person to be making essentially running an illegal sports book out of a phone booth. And so they put a device on top of the phone booth that could be turned on or off with a remote switch, and someone would sit up in a building nearby, and when the guy walked in, they would switch it on, and when the guy walked out, they would switch it off, so that they were only listening to his conversations. They did not get a warrant for this. And so the question, when this was challenged, inevitably, becomes whether the tapping of the phone booth violated Mr. Katz's Fourth Amendment rights. Well, the government argued we never, went into his home. Olmstead says the phone lines aren't tapped. We didn't listen to anybody else. We were, as particular as possible. But the court didn't like this. Now remember, this is the Warren Court, so we're talking a pretty liberal court here. But they said that this violated the Fourth Amendment. And they said that the protection doesn't necessarily apply to a place. It doesn't attach to your home and stay there. The protection stays with each person. That's why, if you look at the beginning of the Fourth Amendment, it says the right of the people to be secure, not the right of homes to be secure, or what have you. So in Katz, they said that the Fourth Amendment covers not only tangible items in your home, but anywhere that you have a reasonable right to privacy. Anytime you believe you have a reasonable right to privacy, and that is something that can be defined as everybody thinks they have a reasonable right to privacy, then you have Fourth Amendment protection. Now, the Fourth Amendment protection that attaches to an automobile is a little bit different. And the U.S. versus Jones case isn't here necessarily to show that, but to show how far technology kind of has come. So the question in U.S. versus Jones is whether the attachment of a GPS tracking device to an individual's car and subsequent use of that device is acceptable without a warrant. Now, what's interesting here, and becomes very important, I think, for the court's decision in this case, is that they had a warrant. They did not get the warrant executed in time, so they didn't put the device on in time, they didn't turn it on in time. The warrant expired, and instead of going back and getting a new warrant, they just essentially went ahead and did it. And so they did have a warrant. There was probable cause. It's just the warrant was invalid at that point. So, really, in some ways, people view this, well, that's just a technicality. But the technicality is there for a reason, and that's what the court says. The court says it's very important that we have this stopgap measure of people having to go to a court and only getting a certain amount of time to do it, because facts may change, things may change. And this is a search and seizure. So when the government got caught doing this and Jones said you can't use this evidence, against me, because the exclusionary rule, as we will talk about later, comes into play, they said, oh, no, that's not even a search and seizure. Your GPS coordinates are not a search and seizure. But the government said, yes, it very much is a search and seizure. This constitutes a search and seizure, and you need a valid warrant for this to be conducted. Again, it attaches to your person. It's not that your car is on public roads, and yes, someone could follow you, but at least you'd have some notice of that at that point. So the search warrant is the general rule. Generally, you need probable cause of a crime being committed or having been committed, and that the warrant will lead to finding evidence of that crime. That's what you have to show to get a warrant. That there's probable cause that there's a crime being committed or has been committed, and that the warrant will lead to the police finding evidence of that crime. It's not a really high standard. In fact, it's the lowest standard we have as a legal system. And yet, it seems like the police constantly want to go outside of this. But for a moment, let's focus on the warrant and what is necessary to get that warrant. And we're going to go into a little more depth in some other cases. But for a minute, let's just try and generally define that. Illinois versus Gates is a 1983 case where you have a cop who received a anonymous tip, and these anonymous tips are not too uncommon. And the anonymous tip is on page 476 of your book, and it dictates to you, you have this couple that's going to be going down to Florida. There's a lot of money involved in this. They're trafficking in illegal activity, etc. And so what the officers do is that they go and get a warrant. So they do what they're supposed to do. But the question is whether the judge should have issued the warrant. All they had was this. They had no idea how to follow up on this tip other than kind of following the people around. But they did verify some of what was in that letter. And so the question is whether that's enough to get a warrant. At one point in time, what is called the Aguilar-Spinelli test was that an informant's reliability had to be tested and shown that there was an information of the basis of the informant's knowledge and veracity of the informant or the reliability of the informant. It's hard to test how true an anonymous informant is. So you need something to be verified outside of that. Here, the court found that they had enough. They were able to partially verify some of the things in the warrant, and they went forward and they tried to get they got the warrant. And so therefore, because they have kind of gone through the steps that are necessary, and really what was available to them, the court says that that's okay. Really what the court comes down to in this case is that they got it right. Had they gotten it wrong, or had it been questionable, or maybe they had a sympathetic defendant, you can see them maybe going another way. But here, they were able to find enough, at least, to hang their hat. So, that's a general rule. You need a warrant. The warrant needs to describe the things you want to search and all of that. But there are several exceptions to the warrant rule. And this is a chart that details the major exceptions to the rule. So you will see the rule, what the rule is, and why we have the rule. So I will let you read through those, but if you look through each of these circumstances, searches incident to a valid arrest, loss of evidence, consent searches, safety searches, hot pursuit, plain view, all of these exceptions have a specific reason that if, essentially it fills in the blank here. If we didn't do this, blank would happen. So if we didn't search here, an officer may be stabbed by a knife while trying to apprehend someone. If we didn't search here, a crime would be committed. If we didn't search here, then evidence would be destroyed. So you can see each of those circumstances has a very specific reason as to why we allow it to happen. Some of the other ones like consent, if you offer consent, if you say, yeah, you can come search my car, I don't care, then that's an exception to the rule because the rule doesn't even need to apply then. If you look back to what the Fourth Amendment says, it says the freedom of the people to be free from. Well, if you subject yourself to it, then you're not taking advantage of it. And that's fine too. Maybe you don't care. Maybe you just want to get it over with. But that does take it out of the realm of needing a warrant. So, searches incident to a valid arrest, pretty self-explanatory. If they do that, they may remove weapons or other items that are dangerous to you or prevent you from disposing of evidence. If you think, next, that the loss of evidence may occur, like someone's in the bathroom getting ready to flush the drugs down the toilet, you can bust down the door. Consent, again, takes you out of the realm of unreasonable search and seizure. A safety search. The police can stop and pat down a suspect that the police believes to pose a danger in order to find and remove weapons. This is a safety of officers and the public thing. Hot pursuit. The police can enter homes and private areas in pursuit of a suspect if it is believed the suspect will evade arrest and potentially harm others. This is one that requires some objective standard because we're having a lot of incidents where hot pursuit is being questioned in recent years. And plain view. If something is sitting out in plain view, police officers do not have to ignore its existence. So if you do this, you're opening yourself up to search and seizure, and it's not going to be deemed unreasonable. Of course, there are exceptions to the exceptions, and the reason why we talk about these exceptions to the exceptions is to define those exceptions. So in Arizona versus Gant, what we're talking about is an exception to the search incident to an arrest. And so you have someone who was eventually arrested outside of his automobile. The arrest had nothing to do with the automobile. It was on an outstanding warrant. There was no belief that he would flee because he was already in handcuffs and on the other side of the driveway. He wasn't within arm's reach of his vehicle, and yet they searched his vehicle as part of the arrest. And of course they found something, otherwise we wouldn't be here. But the question is whether they should have been able to search his vehicle at that time. And the court found that no, they should not be able to search his vehicle at that time. A search incident to an arrest can include a vehicle if the arrestee is either in the vehicle when you arrest him and still in the vehicle, or within reach of the vehicle. But you needed to have some connection to the crime. This guy was arrested for something completely different. So unless you think that there's some evidence of why he's being arrested in the car, and that is connected to the crime itself, there's no reason to do this. And so Mr. Gant gets that evidence excluded. So remember, every time we're talking here, we're not talking about people necessarily being set free, although that ultimately might be the case. We're talking about evidence not being admissible. Safford Unified School District versus Reading. The issue here is whether a 13-year-old student's Fourth Amendment right was violated when she was subjected to a search of her bra and underpants by school officials. There's some convoluted facts to this case, but bottom line, it sounds like she was hanging out with someone who was probably not doing her any favors in terms of staying out of trouble, and that person indicated that she was the person who had provided some over-the-counter drugs and prescription medication, which, by the way, the prescription medication was just prescription strength ibuprofen. It was not exactly dangerous medication. It was, I believe, Motrin 600, so no one's really getting high off of that. And so do school officials have the right not only to search the girl's bag, but to require her to strip search in front of a nurse and then pull out her bra and underpants and shake? This is a 13-year-old girl. And the court said no. This search here violated the Constitution. Now, what they were careful to note is that the school setting changes the standard. It's no longer probable cause. It's just reasonable suspicion. But the reasonable suspicion means that you have to believe that your search is likely to produce something. And so having this poor girl shake out her underwear and bra when really there's no real threat of her, passing illegal drugs to someone, there's no threat of a weapon that they really believed was the case. This is Aleve and ibuprofen, for crying out loud. The reasonableness here cannot at all be justified, and therefore the school was in the wrong and her constitutional rights were violated. So the exceptions here, automobile and the exception of the school setting, and maybe you could add in kind of like a hot pursuit or a search incident to arrest type of thing. But there are limits to the exceptions. The reason why there are limits to the exceptions is because bad things do happen at times. And one of the times in which it's likely that a bad thing can happen is when a police officer stops someone and pats them down. There are many cases of this across the nation, most infamously in New York City, where the police doing this and having not a ton of justification for doing it. And the reason why they're allowed to do it is this Terry versus Ohio case. The question is, in this case, whether this officer was justified in patting down the people that he was talking to in these circumstances. And I think the circumstances are important to talk about. This is an officer who visually confirms that he has seen these people walk in front of a storefront several times, meet up, talk about stuff, and then do it again, over and over again. These people were probably not exactly hardened criminals, but not exactly smart people either. And they were pretty obvious as to what they were doing, which is scoping out a store to burglarize it later. And so he approaches these individuals and starts talking to them, and then becomes somewhat concerned for his safety and pats them down. And of course, we wouldn't be here if he didn't find anything. And so the question is whether this individual, Terry, whether his rights under the Fourth Amendment to be free of unreasonable search and seizure were violated. And the court said, no, this was fine. The Fourth Amendment covers seizures of a person. So you don't need to just talk about seizures of things, but seizures of people. And a seizure of a person happens whenever a police officer accosts someone and prevents them from walking away. Essentially, if you're detained by a police officer but not fully arrested, it's still a seizure for Fourth Amendment purposes. And then, to determine whether it's proper, a court has to focus on the governmental interest which allegedly justifies the intrusion on the protected interests of the private citizen. So they set up this test, and they say as long as the police officer can point to specific and articulable set of facts, which taken together with rational inferences from those facts, warrant the intrusion of privacy, then the officer is in the okay. Patting someone down to ensure that they don't have a weapon is allowed where there's suspicious behavior and police are investigating at a close range. But the key thing for this is that the police have to be able to present an articulable set of facts. An articulable set of facts, a specific articulable set of facts. They cannot just stop you for no reason. They have to present an articulable set of facts. So the remedy for all of this, for all of these cases, ultimately isn't anything but excluding the evidence. And I think that we need to stop and realize how important this is. Most countries do not have an exclusionary rule. If the police use evidence against you, or if the police gather evidence against you in violation of a constitutional search and seizure rule, anywhere else, the remedy for that is not for the police to exclude the evidence when they try you in court. The remedy for that is for you to sue the police for using that evidence. And for many years, that's how it was in the United States as well. And then we developed this exclusionary rule. The Weeks versus U.S. case developed the exclusionary rule for the federal government. That was the point at which federal government followed the exclusionary rule, or it could be enforced against them. And then in Wolf v. Colorado in 1949, that incorporated the Fourth Amendment to the states, but did not require the exclusionary rule to apply. The exclusionary rule was not applied to the states until 1961, and that's in the case of Mapp versus Ohio. The issue in Mapp versus Ohio can be boiled down to this: whether evidence that was seized in an unlawful search and seizure can be used against a criminal defendant at a trial in a state case. So there's no question here that the evidence was seized in an unlawful search and seizure. The only question is whether the government can use that evidence, and the government is state government. And the court finally applies the exclusionary rule to the states and says that all evidence obtained by searches and seizures in violation of the Constitution, and that means the federal Constitution, is inadmissible in state court. Since the Fourth Amendment has been made applicable to the states, the exclusionary rule, the court says, must be applicable as well. While this certainly doesn't stop here, this is where we're going to stop this time. Next time we will talk about all of the exceptions to the exclusionary rule. So you think this is a great thing, fruit of the poison tree, you can't use it in court, all of that. We'll talk about all of that. But then I'm going to show you, sadly, how the exclusionary rule has been chipped away at, and it's a very narrow thing these days compared to what it was in 1961. So we will stop there, and I will see you in class.